The hearing will start now. This is originating application 318 of 2022, summonses 448 and 475 of 2023, Defi Payments Pte. Limited.
All right, morning, Ms. Sheila Ang, Mr. Benedict Tejapranoto, and Ms. Naomi Lim, together with practice trainee Mr. Craig Chua for the applicants, correct?
Yes, Your Honor. Good morning, Your Honor.
Mr. Chua, Sui Tong, and Mr. Russell Ng for the 5th to 9th non-parties, correct?
That's correct, Your Honor. Good morning, Your Honor.
Good morning. All right, let me and Mr. do my elocution. Parties are reminded that there is to be no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present in its location, and parties should treat these proceedings as they would a physical hearing. So this morning, we are here for my pronouncement of decision in relation to the two applications previously heard in February. But before I do that, Ms. Ng, could I just have a short update about what you propose to do if I do grant the extension of time?
Yes, Your Honor. Grateful for that.
Yes, I just need a timeline. What is that? When do you propose to send in the scheme application?
Yes, Your Honor. And with that, I can also refer Your Honor to the affidavit of Mr. Darshan Bhatia.
No, just please summarize for me right now, please.
Your Honor. So we are in a course of updating the terms, the proposed terms of the scheme.
No, please, Ms. Ng, just give me the timeline. Please.
Apologies.
I want to keep it short so I can get to my decision, please.
Apologies, Your Honor. We will file the application under Section 210 by the end of April.
Yes. And I thought the timeline should have been a bit tighter. I thought you'll be applying within April for the scheme meeting.
Yes, that's right. Within April for the scheme meeting as well as a further moratorium extension. So that doesn't change, April 2023.
So when do you see the meeting being held?
Depending on when we get the leave of court to call for the meeting.
What is the target date, Ms. Ng?
We are hoping that it will be between April to June.
No, that's so basically you're asking now for a how long an extension do you want now?
See, what I had contemplated was when we filed the Section 210 application, we will also file.
No, because my 210, even if I grant you an extension of time today, Ms. Ng, it doesn't mean I'm going to give you a very long period after that for your scheme meeting to be held.
I appreciate that, Your Honor.
Your client seems to be taking things for granted, Ms. Ng.
Well, maybe what I can do then, perhaps to be a bit more specific in terms of timing,
Yeah.
I will be able to file the application within 2 weeks.
Within 2 weeks, and then the scheme meeting will be held when, if it's approved?
So it will be because the process contemplates the adjudication as well as the.
So how long in total then, Ms. Ng?
We're looking at about June. In terms of
June. So basically asking for is essentially if I grant an extension now, nothing will. You only have the meeting in June.
Yeah, we don't hope it's faster. Maybe what I can say that we contemplate that it will be within 3 weeks of the grant of the Section 210 approval for leave to be to convene a meeting, and that's because I'm not so sure in terms of timing when that will bring us. But what we are looking at is about 3 weeks, and this is in our letter of 10.
No, just because you send a letter doesn't mean anything, Ms. Ng. Ms. Ng, you're really making me very annoyed on the Monday morning that there seems to be a lack of appreciation of the urgency of this matter, Ms. Ng. That's why Mr. Chua on their side has been quite strenuous in his objections to the extension. I would have thought that given all of this, there would have been a bit more promptness in what you're lining up, or what you're seeking to line up, Ms. Ng.
Yes.
No, you're not. June, you don't seem to have any, your client doesn't seem to have any inkling of the urgency of this matter.
Yeah,
Why grant you an extension in these circumstances then, Ms. Ng? I wanted to give you an opportunity this morning to give me a brisk timeline. This is not brisk.
Okay, perhaps, Your Honor, what I can do.
No, don't use okay in court, please. Ms. Ng, I'm going to stand down for a few minutes. Get everything in order. You've had a month to basically get everything actually in terms of a timeline. I expected something brisk, something fast. Justify why you need this amount of time at this stage in the proceedings. I would have thought you'd be raring to go for the meeting.
Yes, Your Honor, I appreciate that.
I don't see that, Ms. Ang.
Apologies, Your Honor.
Give me a concise timeline if you have any. If you don't, fine, so be it. So stand down for 15 minutes.
Grateful, Your Honor.
Sorry,
Please
Sir.
adjourn.
Yes, sir.
We will resume the hearing now.
Yes, Ms. Ang, we're resuming.
Yes, Your
What's
Honor.
the position now?
I apologize, and maybe what I can do is I will set up the timelines. So of course, hearing Your Honor, taking into account, the what we could do in terms of streamlining the timeline, but that's subject to Your Honor granting leave to deviate from the regulations.
Yes.
And to file the application by the 12th of April. This is
Mhm.
a 210 application for leave to call a scheme meeting. Together with that application, we will also be asking for a streamlining of the timelines in relation to the scheme, and also deviating from the traditional scheme of arrangement meeting. Assuming that leave is granted, we intend to issue the notice of the scheme meeting the day after, 1 working day after the leave is granted. The meeting will then be called by way of an information town session. And it's proposed to be within 7 days of the notice of meeting. So that brings us, if I assume that leave is granted on date D, it will be D+8.
Mhm.
And this is where subsequently also using D as the reference timing, D+14 in relation to the inspection and resolution of any disputes of claims.
All right.
So that brings us D+14. And also then the voting period. We are asking for a voting period of D+21. So this is to ensure that any creditors with any claims that are being disputed will have 7 days after the end of the dispute period to vote. But subject to Your Honor, maybe we can actually shorten that time period to a shorter period. And then thereafter, 1 week after the voting period ends, we make that application for sanction.
All right. One thing I need to make clear, Ms. The shaving off of time is not meant to prejudice the voters. What I'm concerned with is the applicants aiming to take their time lining everything up.
Oh, yes.
All right. So it's not to cut down on what the voters should have. Is what I am very upset about is that I don't get the impression that your clients are really lining things up properly so that the votes and all that will take place properly and the meeting is called properly. So you're not going to satisfy me by shaving off the time that the voters have or the creditors have. Bear that in mind, Ms. Ang.
I apologize for that.
All right, so you line it up accordingly, but make sure whatever you propose doesn't prejudice the voters. Your applicants, your other advisors need to work hard. I don't know what resources they need to put in place to make sure everything is done properly, but that's my concern, not to cut down on what the voters have. Do you understand that, Ms. Ang?
Yes, Your Honor, I understand. I apologize for misunderstanding earlier. I think
I will deal with that later if I do grant you the extension of time. Hold on a moment. I need to emphasize the clients, they have taken on this process. They are the debtors in possession. They're the ones who want the process to continue. They need to understand, though, that this, as Mr. Chua has pointed out previously, you've been at it for what, 7 months, 8 months now? And I would have expected things to be lined up. I appreciate that there are some complexities here because of the sheer number of people involved, as well as the kind of assets involved. But you need to line things up properly so that I'm assured that your clients are not trying to stretch things out. You understand that, Ms.
Yes, Your Honor.
Right,
And
so there's a couple more in my mind. And so I will have a number of concerns if leave is granted, but I'll touch on that after I give my decision. You take back what I say in my remarks this morning, and then we'll see where we are. All right.
grateful for that, Your Honor. Perhaps I could just add, Your Honor, in the 12th affidavit of Mr. Darshan Bashir, we have given an update on the developments and that the clients have been continuing to work very hard on the proposed scheme of the proposed terms of the scheme of arrangement.
The other parts of Mr. Darshan's affidavit, which I do not think are really relevant in terms of the plan and were really rebuttal to matters raised in the letters.
Yes, Your Honor. Only at
We'll not go into those.
yes.
All right, so Mr. Chua, I will just be proceeding to give my decision this morning. I just wanted to understand what the timelines were. Should I give extension? And I will speak with counsel again after the decision is handed down. And also, I would just note for all the other attendees or those watching online that there's no chat function today, as I'm just keeping my decision. The rest of it will just be in terms of confirmation of various matters with the lawyers. All right, let me then proceed to hand down my decision. So these will contain remarks which will be circulated after today, very shortly after today. So this hearing is for the pronouncement of my decision in respect of the applications to extend the moratorium previously obtained by the applicant company, as well as the application for permission by certain creditors to proceed with a winding up petition or application. As these applications were interrelated and could conceivably impact, each could conceivably impact on the other, I heard them together, but I'll this morning only give brief remarks, and these will be added to if necessary. The applicant company sought an extension of the moratorium to allow it to have more time to prepare for an application for a meeting on its proposed scheme, which would involve a wind down of its positions. The creditors opposed the extension of the moratorium and sought permission of the court to apply for winding up the company. In an application for extension of a moratorium, the court will need to consider whether further time should be given to the applicants and the requirements relevant to the granting of the initial moratorium extension under Section 64 of IRDA remain in play, namely whether on a broad assessment, there is a plan that has a reasonable prospect of working and being acceptable to the general run of creditors. It is not necessary to garner or show support meeting the statutory requirements. However, as time passes and extensions are granted, the court will, as I have noted on several occasions, require greater assurance that there is a point to any further extension and that the application is not made in order to simply prolong things or game the system. The court will want to see evidence of progress or action, so what counts as such evidence will depend on the specifics of each case, including its complexity and difficulties encountered. In the present case, there may be logistical issues given the sheer number of affected creditors, but I do not accept the creditors' arguments that there is no realistic prospect of the proposed scheme working. While there may be issues about the proposed scheme, particularly its cost, effectiveness, and other difficulties, these do not be set to my mind to be of the level that would call for refusal of an extension, in contrast to cases such as Ray Aquaverse. I should not remove consideration of the proposed scheme from the meeting of creditors should one be called. I further accept that there has been sufficient evidence shown of the possibility of the proposed scheme being acceptable to the general run of creditors. Whether the applicants do manage to persuade the required majority to do so or not is another matter and can only be determined at the meeting. I've received many emails, many of which express doubts about the proposed scheme, but many as well which have supported the proposed plan. The court understands and sympathizes with all the investors who are anxious and concerned about their funds. But I cannot, in these brief remarks, do justice to the numerous emails received and the individual circumstances and views mentioned. But while the court notes that there have been a great many emails sent in, the court must proceed on the basis of the legal framework laid down in the IRDA. And the role of the court at this stage is simply to consider whether sufficient basis has been made up for an extension to be granted, and the court does not conduct the vote itself. I am satisfied that applicants have shown sufficient progress and development that there is a reasonable prospect of the proposed scheme being acceptable, and that there has not been any lack of bona fides or gaming of the system. I do still have concerns about the shape of the meeting and how the vote is to take place, but this is not the appropriate juncture for that to be considered. That will be determined at the application for the calling of the scheme meeting and subsequently when approval of any plan is sought. As for the application for permission to proceed with the winding up, I'm satisfied that leave should not be granted. Winding up is incompatible with the debtor in possession framework embodied in the moratorium and scheme regimes under ERDA and the Companies Act. It will pose a substantial distraction and undermine the continued pursuit of the restructuring. Whether or not the scheme is put to the vote and whether it will be successful otherwise are different matters. But while I will not grant the application for permission at this time, I do not dismiss it and keep it in abeyance pending the further progress of this case. The creditors behind this application may seek to renew it should circumstances change. I thank both counsel from both sides for the assistance in this matter. And the extension of moratorium is thus granted and no order is made at this time on the application for leave to proceed with the winding up application. And I will now confirm the specifics of my orders with counsel. So Ms. Ng, so those are my remarks. As you would have noted, I am concerned about the shape of the meeting and how everything's to be done. I will give you an opportunity to assure me of these when the scheme meeting application is made. But overall, I would like the whole matter to proceed to the meeting as fast as possible without compromising the interests of the creditors. All right. So
Yeah.
with that in mind, what extension of time are you seeking this morning?
My proposal in the summons was for an extension of time up to the hearing of the Section 210 application.
Yes, and that will be
And with my proposal to file the application by the 12th of April, having regard to the time that will be required for any creditor to file response affidavits for hearing time, I think I can stick to the original date that's being sought, which is the 28th of April, Your Honor.
so you're 28th of April for the extension, but you will file the Section 210 application by 12th April.
That's correct, Your Honor. And also at the same time, I will be filing a further extension of the moratorium.
All right. Extension is granted to 20th April 2023. Section 210 application to be filed by 12th April. ARPTC to be convened by the 14th of April. Right, extension is granted to 28th April 2023 or other order of court. So if I don't see anything by the 14th of April and I'm so informed by registry, I may terminate it. All right, Ms. Ng?
Yes, Your Honor, I understand.
All right, 14th April. All right. So in the meantime, then, Mr. Chua, so your client's application is not dismissed. It is in abeyance. I will see how things progress. But if you think the circumstances merit it, you may write in or apply orally to the court to revive the application. All right.
Yes, sir. I'm grateful.
All right. All right. So we'll proceed on this basis. So Ms. Ng, bear in mind my remarks. Briskness, but not at the expense of the voters, please. All right.
Yes, Your Honor.
My irritation at the time is directed solely at your clients and their advisors. They need to line things up. I'm not going to be very amenable to delays if I see that if I have doubts about the basis for the delays. All right.
Yes, Your Honor. And we'll take you through the proposed timelines at the next hearing.
All right. Make sure you bear that in mind. All right. I want the voting and everything to be detailed as well. The voting mechanisms and how you're going to do it with, sorry, I can't remember how many thousands of creditors you have here. All right.
Yes, Your Honor.
All right. Right, so that is my decision. The remarks will be ready shortly. You may collect this. So, all right. So, Ms. Ng, just bear that in mind, convey it to your clients. All right, anything further, Ms. Otherwise?
Not from me, Your Honor.
right, Mr. Chua?
Not from me on.
All right, thank you both. All right. For the
Thank
session.
you.
All right, thank you.
Thanks, Surgeon.